Welcome to the webinar, MedLegal Suggested Precautions, a case-based discussion. Today we will be discussing a case that was decided by the National Consumer Commission, published in the Medical Law Cases for Doctors in the December 2016 issue. The case is of Apollo Speciality Hospital versus R. Muthukrishnan. We will be going through the case, the learning points, and thereafter we will take your questions and answer them. Let me take you to the facts of the case. The patient, very unfortunate, a 12-year-old boy, was examined by the doctor at the hospital and diagnosed with leukemia. The patient was in remission, given chemotherapy treatment, was normal for approximately 8 months with no special complaints. Thereafter, the patient was admitted. Half identical stem cell transplantation, BMT, was performed. Post-transfusion complications were there, and the patient died about 4 months after BMT. The patient's father, he filed a case against the doctors as well as the hospital. Some very prominent allegations that he made. One of them was that the patient was referred to another doctor at CMC Vellore who did not give any opinion, yet the doctors at the hospital performed BMT. The next allegation was that there was no informed consent, as the risk mentioned in the consent form was 50% mortality with 100 days. But in the court, the doctors and hospitals had stated that the survival rate in BMT is only 5 to 10%. Thus, the consent was taken by misrepresentation and suppression of material facts. Adequate and necessary information was not disclosed to the patient. The next allegation was that Foscarnet was prescribed but was not available in the pharmacy attached to the hospital. Furthermore, no steps were taken to procure the said medicine, either by the hospital or by the doctors. Many other allegations were also made. One of them was that the doctor compelled and prevailed upon the patient to undergo BMT urgently. They could have waited. Investigations to rule out any possibility of the presence of CMV virus was performed at a very delayed stage. Post-procedure, the doctor left for abroad when the patient was critical. Instead of giving palliative care, DNR procedure was adopted. And lastly, that the hospital did not give medical records within 72 hours, though such a request was made. The patient's father pointed that this was in gross violation of MCI regulations. The doctors and the hospital in defense accepted that the patient was sent for opinion to another doctor at CMC Vellore. This doctor made extensive worldwide search for a stem cell donor in the intervening period of approximately 6 months. Approximately 20 million donors, including cord and marrow, were considered, but none of them matched with that of the patient. As time was essence of the treatment, due to non-availability of a full matched stem cell donor, the patient was advised to undergo half identical stem cell transplantation, as only the patient's mother's cell half matched with the patient. The next contention that was raised by hospital in defense was that since it was a half cell transplantation, the patient came under the category of high risk. Informed consent was taken before BMT. The patient's father was informed that the survival chance without transplant was close to 0%, and even with high risk transplantation, the survival was only 5 to 10%. And after being informed of the said fact, he signed the consent form. The doctor agreed that he left for abroad, but he also pointed that in his absence, the patient was under the palliative care of a senior oncologist and a pediatrician. The court held that the doctors and hospital were not negligent. The court found that a very elaborate DNR form was signed by the patient's father in the presence of the doctor. The court did not comment whether such a DNR form, such a DNR instruction was legal or not. The court held that consent was proper as the procedure was correctly named. Advantages and disadvantages of different alternative treatments were mentioned. It was properly signed by the patient's father. The court specifically took note of the handwritten note of the doctor in the consent form, wherein it was clearly recorded. High-risk consent explained to father, haplograft relapse plus infection can cause mortality of 50% in the first 100 days. Very clearly, the risks were laid down. The court also drew favorable inference in favor of both the hospital and the doctor, as an extensive search was made for matching. Expert opinion of another doctor from CMC Vellore was sought, and the standard medical protocol was adopted in treating the patient. The court therefore held that neither the doctor nor the hospital was negligent. Now let us discuss the suggested precautions, the learnings from this case. The first learning is, do not leave a patient under treatment midway, especially for treatments and procedures that require special or extraordinary care. We saw that in this case, one of the allegations was that after performing BMT, the doctor left for abroad without proper care. The doctor pointed out in defense that in her absence, the patient was under the palliative care of a senior oncologist and pediatrician. The court accepted this defense. But it is important for doctors to know that they cannot leave a patient under treatment midway, especially treatments and procedures that require special or extraordinary care. Emergencies of both the doctor and the patient would be an exception. If an emergency comes as far as a doctor is concerned, the doctor needs to inform this fact to the patient, hand over the patient to a proper substitute, a competent substitute, and then the doctor can proceed on his or her leave. Similarly, if a patient comes who is in emergency, the doctor can inform the patient that he is going to on a scheduled leave and will not be able to take care of the patient. The ones who are getting caught by courts and the frequency has increased a lot in the last few years, are surgeons. Surgeons who are going on leave after the surgery, not providing post-surgery care. Let us not forget that a surgeon's duty is not only to perform surgery, but also to provide post-surgery care. The next learning from this case: do not follow end-of-life instructions such as do not resuscitate, allow natural death, living wills, and so on, as they are not legally recognized in India. We saw in this case that the patient was diagnosed with leukemia. He was under palliative care, and his father did sign a DNR form in front of the doctor who was treating the patient. But later on in the court, the father tried to indirectly challenge this DNR. The court has not expressed its view, and certainly the doctor was not held negligent for either taking the DNR instructions or following them. Nevertheless, following such instructions is presently risky and should be avoided. 1 year back, whenever we used to get requests for DNR and A&D, our opinion was that yes, the doctor and the hospital should follow them. But not now, especially after the government of India has brought the medical treatment of terminally ill patients bill. It seems that the policymakers intend to limit these instructions only to terminally ill patients. Section 11 of this bill very clearly lays down that DNR instructions, A&D instructions will not be accepted, are not legal in India, except in cases of terminally ill patient. The next learning from this case: exercise greater caution and care in recording the exact percentage of the risk in consent. Avoid if possible. In this case, it was alleged that there was no informed consent, as the risk mentioned in the consent form was haplograft relapse plus infection can cause mortality of 50% in the first 100 days. The doctor had very clearly written the figure 50% in the consent. However, in the court, the doctor stated that the survival rate in such high risk BMT is only 5 to 10%. The patient's father tried to point out that he was misguided by this percentage. Although the court held that the consent was proper, greater care ought to have been taken in disclosing the percentage of risk. Doctors usually copy the percentage of risks written in textbook. It is a good practice, but it should be avoided because it is open to challenge. One textbook may give the percentage as 50, another may give it at 45. And when these things reach the court, they obviously create some problem for doctors. It is therefore advisable that general terms like high risk, average risk should be used instead of clearly stating the percentage. Let us also remember that in India, writing percentage of the risk is not mandatory in consent. What is required is only disclosure, and one has to enumerate all the risks which can occur in a therapy or a intervention, and where the chances of happening are 10% and more. To summarize, friends, we take 3 learnings from this interaction. The first one: do not leave a patient under treatment midway, especially for treatments, procedures that require special or extraordinary care. Do not follow end-of-life care instructions such as do not resuscitate, allow natural death, living wills, and so on, as they are not legally recognized in India. The third learning is exercise greater caution and care in recording the exact percentage of the risk in consent. Avoid, if possible. Let's take questions from our live audience now. I will personally provide my response to the questions that may not be addressed during this webinar. One question comes, though it is not directly related with the three learnings from today's case. One request that I would want to make to all of you is, if we can restrict the questions to the three suggested precautions that we have discussed today, it would help us in understanding the various contours of these problems better. But anyway, if general questions come, I'll be happy to take them. One question comes from Dr. Amit Malhotra. Do we need a lawyer to represent our case in consumer court, or can we do it ourselves? You are asking this question to a lawyer. Anyway, the answer is yes. You don't need a lawyer to represent yourself in a case anywhere. Not only in consumer court, even in a civil court, even in a criminal court, the party himself can appear. Yes, you cannot appear for an other person, but for your own self, you can. But nevertheless, the legal procedures that are followed in consumer courts are a bit complicated. And that is why it is advisable, not mandatory, that an advocate should be engaged. Second question comes from Dr. Brij Mohan Rai Khadria. The question is, what is the role of general surgeon in performing surgery in orthopedic, nephrology, and other specialities? The biggest problem that we lawyers and courts face is that the privileging of different specialities in India is not at all present. Neither has the Medical Council of India done this exercise, nor have the national medical associations done something like this. Now, a procedure like hysterectomy, we always suggest that a gynecologist should perform it. But we don't see any reason why a general surgeon could not do something like this. Specialized treatment, specialized procedures like orthopedic, nephrology can and must always be performed by the relevant specialists. The next question comes from Dr. Anugiti Chelli. Can a family doctor conduct deliveries? Answer is yes and no, except in emergencies. If there is a dire emergency, labor is progressing, then yes. Why only a family medicine doctor? Anyone can perform deliveries. Otherwise, the job of delivery is best performed by obstetricians. Next question comes from Dr. Gurudat Joshi. Seems to be a very big question. Let me read it. What are the vicarious liabilities of treating doctors at the level of resident doctors, assistant professors, associate professors, head of the medical superintendent, and dean treating in a case of medical negligence in a particular department in a municipal corporation medical college? You seem to be an advocate, not a doctor. You are raising issues like vicarious liability. Yes. Let us understand what is the vicarious liability of a doctor. Vicarious liability, in simpler terms, in a layman's language, means that a master is always responsible for the wrongs done by the servant. The captain of the ship is responsible for all wrongs that have happened in the ship. Similarly, in case of a patient, it is the doctor in charge of the patient who is responsible for all the wrongs that have happened, for all the negligent conduct. This is the general law. But as far as municipal corporation hospitals, government hospitals, medical colleges are concerned, the law would be and is to a certain extent different. Here, courts do take into account that even though the patient may be admitted under a head of department, the law of vicarious liability does not come into play in a strict sense. Again, we are awaiting for a proper judgment, a complete authoritative pronouncement on this aspect. We expect someday, as the number of cases keep on increasing, someday the law will be clarified in absolute black and white. We have another interesting question from Dr. Mukesh Khare. The question is an ophthalmologist PG from Government Medical College but not recognized by MCI eligible to operate cataract? This answer neither a lawyer nor a court will be able to answer. It is for the Medical Council of India to answer. On sound legal principle, again, this should not be taken as the last word. Yes, if it's a medical college from where the doctor has done his PG, he obviously is authorized to do a simple surgery like cataract. Next question comes from Dr. Shantaram Gulve. Can a general surgeon perform hair transplant surgeries? What is legal aspect? Who can do hair transplant? Now here we have dermatologists, we have cosmetologists who are fighting with the general surgeons who has the authority. Again, I have tried to answer this earlier. It is for the Medical Council of India. It is for the national medical societies to privilege, to lay down who can do what. Next question again is an interesting question from Dr. Shashikant Verma. Can any doctor on the basis of autopsy report, and here he says autopsy done by another doctor, issue death certificate? My question would be, why would the doctor who had done autopsy not give a death certificate? The doctor who has done autopsy should give, ideally give death certificate. Generally, death certificate is given by the doctor under whom the patient is admitted, under whom the patient dies, who has seen the patient for the last few days before his or her death. Next question comes from Dr. Sanwal. A patient is brought dead in hospital emergency with age around 70 with chronic illness, and the patient attendant does not want MLC but requires death certificate. What should be the procedure followed by a casualty medical officer? Very usual case. Every other hospital, every other doctor in the country faces this. Law is very clear. If a doctor comes across a dead body and the doctor is not aware of the cause of death, the doctor must inform the police to come and take the body and perform post-mortem. Doctor will only make it as an MLC case. Doctor should not give a death certificate. But the moment the doctor announces that he will be referring the body to the police, the patient's attendants, they start creating problems. Anyway, this is the law. It has to be followed tactfully. Next question, and perhaps the last one. we are running out of time, comes from Dr. Suthanthira Kannan. Sometimes not all the information about the disease in oncology discussed with the patient are recorded in the file. But the general consent form clearly states that I have been allowed to ask any clarifications and all my questions have been answered. Can the patient claim in the court that any particular issue was not discussed? Dr. Kannan, you are talking about a legal concept known as therapeutic privilege to a doctor. Law recognizes that every doctor has this privilege if the doctor is of the opinion that giving a particular opinion, giving a particular information to the patient will actually harm the patient, then the doctor can decide not to answer the questions or to give the requisite information. But doctors need to be very careful in exercising this option. I would suggest two very simple precautions. Number one, this information should certainly be disclosed to the attendants of the patient, to the relatives of the patients, and their consent, their endorsement on your internal medical records must be taken that they have consented, they agree with you that this information must not be passed to the patient. Number two, if possible, discuss this case with one of your peers, ask him to endorse the view that you take. It will further help you if tomorrow some legal problems arise. Friends, I was wrong in saying that this was the last question. I am told that we still have time to take two questions. I'll take two last questions quickly. One from Dr. Sonia Parikh. Can a terminally ill patient leave treatment against medical advice? What medico-legal aspects should be covered by the doctor in charge? Leaving treatment against medical advice, this is an absolute right which a patient does have, whether he is terminally ill or not, and the doctor can hardly do anything. Only precaution that the doctor should take is to get a discharge against medical advice form or something like this properly filled, take signature of the patient, and if you anticipate problems, ensure that something like this is also signed by independent witness. And the last question, friends, from Dr. Dipti Gupta. Should we inform patient regarding risk of ureteric injury or obstetric hysterectomy during cesarean, as risk is very less, as it creates panic to patients and relatives? Law has been very clearly laid down in the case of Samira Kohli versus Dr. Prabha Manchanda, decided by the Supreme Court of India in 2007. And the Supreme Court of India did take into cognizance the fact that if too much of information is relayed to the patient may run away. Too less information, again, does not make a proper informed consent. Supreme Court again has laid down that if a particular risk is 10% and above, if you find that risk to be 10% and above in your standard medical texts, then you are bound not only to disclose it, but to clearly record it in the medical records in the consent also. Now, what is the risk of ureteric injury or in an hysterectomy? That you can find out from your text. If it is 10% and above, then definitely you will have to inform the patient. If not, then you can do away with informing the patient or recording it in the consent. Friends, we are done with the questions. I have been informed that there has been an immense response for this webinar. I would like to thank all our viewers for their participation and will surely answer all other questions asked during the webinar. Please post the questions in the discussion section after webinar. Thank you.